Welcome to another edition of Your Long Range Plan. My name is John Kennan. I'm an attorney here in Sandwich, and I practice primarily in estate planning law, along with my colleague Paul Tierney.
Welcome.
Thank you. And he maintains an office in Quincy, Massachusetts. Paul, I think today we're going to try something a little different. I've been a little technical at times. I think I've kind of used terminology that may cause people's eyes to glass over, and perhaps we should just keep it as simple as we can. And maybe today we should talk about joint bank accounts, the pros and cons of a joint bank account, and if you could expand on some of your own experiences with regards to jointly held bank accounts.
Yeah, well, it's interesting, John. Just recently I had a conversation, right over the kitchen table about, a couple of people, relatives of mine who, they've done some estate planning, but they have their checking accounts set up with, one of their sons involved as a joint account holder. Now, and it's important to realize that a joint account on a person's demise will pass automatically outside one's probate estate directly to that joint account holder. Now, most of the times people will set up joint accounts with, say, one of their kids or one of their siblings for the sole purpose of making it easier to have the other joint account holder pay bills, or if that person passed away, so that they'd be able to pay off the funeral expenses and other costs associated with the death. So many times people will do that. They'll set up a joint account with somebody and with that express intention. But like everything else, estate planning wise, it's important that you communicate with people. Now, most of the times people want to have whatever's left over as part of their estate. They want it to go in a certain direction. And if they have children, many times they want it to go equally to the surviving children. But they may just have one of the children involved as the joint account holder for convenience purposes. So I think it's important to know that you got to communicate. That's okay if you do have an account set up like that. But just realize if there's money in that account, yes, that joint account holder, son or daughter or sibling, can have immediate access to that, not only during lifetime but at death for payment of bills, expenses, and what have you, but that the rest of those monies will go directly to the joint account holder. And that may not be what the decedent intended. So it's important to communicate to the people that you are having involved with your estate plan, usually it's your beneficiaries, what your intention is.
So let me ask you a question. You and I construct durable powers of attorney, which gives so much power to the designated or appointed attorney, in fact. And we always, or often, will tell our principals, the client, that the person that they're naming the attorney, in fact, has all those powers or is able to step in to the shoes of that person to do everything that the principal would normally do for him or herself. So could you talk to us about the check writing capabilities, the opening and closing of bank accounts with a power of attorney? Is that preferred, that power, over the jointly held account situation that you've just outlined?
There's a distinction, and that's important. The power of attorney can be broad or it can be very restrictive. Usually in most family situations we want the power of attorney to be very broad because we don't know what we're going to come up against or be involved with during the lifetime of the individual. Many times we may have to get information on life insurance or bank accounts that have been closed out. And unless your agent under the power of attorney has the authority to deal with, say, life insurance policies, which has to be spelled out, or bank accounts or closed bank accounts, then they're not going to be able to necessarily get the information that we may need. But there is a distinction. The power of attorney, that's a legal document, and it should be part of everybody's basic estate plan. That person appointed as the agent ceases to be agent on the death of the principal. So if an elder passes away with a power of attorney naming one or more of the kids, that document ceases to be effective and available at the death of the elder. So again, to contrast that with a joint account person can still pay bills with a joint bank account as opposed to a power of attorney person who's named on that bank account. That authority to act to pay bills ceases at the death of the elder. So a very, very important distinction. Many times people will ask me, what's a better way to have it set up? And the answer to that is it kind of depends. Like I had this discussion with a relative of mine recently, and I said to her, hey, did you make sure that you spoke with your son who you had on as the joint account holder? Does he know that, hey, whatever's left over, the intention is that that be split with any of the other assets that are in the estate with the rest of the kids? Because that was how she had set up her estate plan, that everything go equally to the kids. So again, it's important that you have that discussion. And the elders or the people whose estate plan it is can really take it a step further and discuss it with, say, all of the children if they want it to be split equally. And sometimes it's as easy as saying, hey, we're appointing, son number one as the joint account holder because he's around. He can pay the bills. And I'm concerned that I want my funeral and any expenses associated with my death paid off, immediately, at my demise. So if it's set up jointly, then the son or the daughter, who's ever appointed, can do that immediately, and that ability to pay bills or to act on behalf of the elder will not cease at the death of the elder.
And that speaks clearly to the convenience component.
Exactly.
Yeah, and that has to be very clear, that an account is being set up jointly for convenience purposes only.
And again, I think one of the best things that you can do if you decided to go that route would be to have a discussion with all of the kids, especially if the intention is that it be split equally, or that if there's anything left over in that joint account or joint accounts, that go to all of the beneficiaries. So again, that conversation needs to be had. But even still, it's important to know, and I try to point out to people doing their estate planning, that even if you do set it up like that, hopefully the joint account holder individual is going to do the right thing. But now you're relying on destiny as opposed to operation of law. So there's a better way, I believe, of accomplishing maybe the same thing. And there's several different routes that you can go. One is the power of attorney, which we talked about. But many times elders or anybody, they have the concern that, okay, if I die, if it's going to be frozen at that point, what about paying my bills? What about paying off the funeral expenses? Or what about the meal after the funeral? How is that all going to get taken care of? And that's a legitimate point, because the power of attorney does freeze and ceases to exist at death. But again, having dealt with a lot of these issues in the past, you find out that even if there was a funeral bill to be paid, a lot of your funeral directors are very understanding and will wait till somebody's appointed through the will to act before the bill can be paid or will be paid. And even taking it another direction, I recommend that if people are concerned about that, is to do a prepaid funeral contract. I think that makes a lot of sense. When somebody passes away, there's a lot of different things going on, emotions, concerns, contacting family. If the funeral arrangements can already have been set up, I think it makes it easier on everybody. But again, if that is a concern, the easiest thing to do is do a prepaid funeral arrangement. But even if that hadn't been done, again, many funeral homes and funeral directors are pretty understanding, and they will allow the bill to be paid when somebody's appointed through the will.
Okay, excuse me. We've talked about jointly held accounts, durable powers of attorney, so someone has the check writing capability, et cetera, and the pros and cons of either jointly held accounts or durable power of attorney the exercising of powers as a power of attorney. What about a checking account titled in the name of a family's trust or an individual's trust? Any merit in titling a checking account in the name of a trust?
Well, if people are going to have a trust as part of their estate plan, then I do recommend that you fund the trust with your checking account, because that would avoid some of the issues and concerns that we just talked about. If a person passes away and their checking account is funded in the trust, then the successor trustee, which is oftentimes the surviving spouse or one of the children or a sibling, they can step in as the successor trustee and pay bills the next day. What they would have to do is bring the death certificate down to the bank with a copy of the trust and show that they are designated the successor trustee. And at that point, the bank, the checking account institution, would have some paperwork for the successor trustee to sign, and they'd be able to pay bills that day. So that's, I think, an even better way to have that type of an arrangement. If you had a trust, if that made sense with the type of estate plan that you had in place, that checking account be funded in the trust. And then that person can, the successor trustee can take over immediately after the death of the elder.
And how about during one's lifetime? If I created my own trust, could I not fund the trust or title a checking account in the name of the trust and have checks printed out with the name of the trust and having myself and or another individual as a trustee to have that check writing capability?
Yes, you could definitely do that. In fact, just recently, one of my long-term clients called me, and her concern was she had everything funded in her trust, which was wonderful, even her checking account. But her concern was that she wanted some of her other beneficiaries to be able to help her out and to go down to the bank, to be able to pay bills for her, to be able to withdraw money if need be. And the concern was the only one who could do that was herself, because she was the trustee of her trust. So in her situation, to solve that issue was pretty straightforward. We basically added a couple of her beneficiaries as co-trustees, so that any one or more co-trustee could act on behalf of the trust. So that enabled these individuals, if she didn't feel like going down to the bank, or if she needed to take money out of the bank and couldn't get there, or if bills had to be paid and she wasn't able to do that herself, then her beneficiaries who were appointed as co-trustees with her had the authority to do that. So that was a way that she accomplished that goal of being able to have other people access the checking account, which was funded in the trust during her lifetime. Many times these trusts are set up so that during lifetime it's just the elder or just the individual who is the trustee, the person in charge of the trust. And I think that makes sense for lots of different reasons, because it's that person's money, that person's assets, and they should be in control. But sometimes if they get older or they get to a point where they're getting a little insecure about being able to handle their own financial affairs, that's a good point to take a step back and to review their estate plan like this particular person did, and she felt that, you know what, now is the time to get some of the other beneficiaries involved to help her if she needed help during her lifetime, such as being able to go down to the bank, pay bills, and things like that. Now the trust is still, in this situation, the trust is still set up to benefit her during her lifetime and nobody else, but now we have more than one person being able to access accounts, bank accounts mostly, for this person's benefit during her lifetime, if she should become sick or if she wasn't feeling capable of being able to pay her bills anymore.
And this goes so clearly, again, to our whole principle of educating our clients in terms of planning. It's part of the planning, preserving, and protecting, but planning is key. And everything we're talking about here today is present-day planning that has a lot of influence on planning later in terms of the legacy. So this is really good. This is a really good discussion we're having. Just on this one topic alone, you have highlighted some experiences that you've had. You've outlined several or more experiences that I've had with clients that, although I communicated clearly to them, the advantages of a jointly held account and what happens if you don't save for convenience. And sometimes you and I will hear, well, don't worry about it. I'll take care of that. I'll take care of that. Mm-hmm. And oftentimes, even though you and I are constantly calling clients, reminding them, they don't do certain things. Much to the surprise of surviving, beneficiaries in the case of a trust, and much to our surprise too. But we can only do so much in terms of helping our clients along and making suggestions and planning.
And recently, we did have a case where, client, single person that didn't have any spouse or any children, but several siblings that they wanted to benefit, and they went to the extent of, again, kind of creating their own estate plan by setting accounts up jointly. Mm-hmm. And we know that this person's intent was to really benefit her 3 siblings. Mm-hmm. So she passed away, and yes, some of the accounts were jointly held with one sibling, another one was jointly held with another, and another like brokerage account was jointly held with a third. Again, the intention, at least some of the family members felt, was that everybody be treated equally of the 3 siblings that this decedent left behind. So when the time came, our clients, agreed, hey, this $100,000 bank account, she would add that into the pool to be divided up equally. Mm-hmm. But one of the beneficiaries, who ended up with I think it was a $50,000 account, felt that no, that was meant to go directly to her. So she did not add that into the pool. And that caused a big family ruckus because, again, the other siblings felt strongly that the decedent sibling wanted to benefit everybody equally, even though the accounts weren't set up equally. Again, joint accounts. So that's a situation where I'm not sure what went wrong, other than, again, my preference would have been to have those accounts all put into a trust or spelled out in the will that my intention is, if I do have any joint accounts, that the joint accounts be used as part of my estate and be divided equally to the beneficiaries. That's another way of being able to address accounts that are held jointly. But another way is to have the conversation with all of the people involved with your joint accounts. But now you're relying on destiny for them to do the right thing. And as I saw in this one particular case, we had one beneficiary, one joint account holder, who didn't do the right thing, who kept the money, and much to the chagrin and surprise of the other siblings. And that caused a rift in the family, and that could have been easily avoided had the decedent been crystal clear as to what her intentions were, or better yet, had gone to the extent of setting up her own estate plan where she addressed this specifically and legally.
And I'm glad you say it in that context because, again, we do our best to counsel our clients. We listen to them, oftentimes say to us that my kids are great, they're good, they're going to look after one another. But we can't predict that that's going to be the case with certainty because of times. Present day is a lot different than the future. You've used the word destiny twice. Changing circumstances, that particular household's needs or wants and financial circumstances may lead them to make decisions that aren't necessarily in accord with what their mother or father would have wanted. So we're not trying to cast blame. We're just trying to educate to say, be mindful of the fact that we're all human beings. We do the best we can. And unless there are very specific guidelines that somebody can refer to when they're communicating with another sibling or whomever, in other words, to be able to pick up a will, if you will, and say, well, this is what mom and dad wanted. I'm just following their directive. Unless it's that clear, then we're all subject to some of the nuances of life and the present day
Well,
times.
and you're also going to be subject to different opinions, because if you have 3 beneficiaries but no direction from the decedent, then you're going to have probably 3 different opinions as to what the decedent wanted to do.
In believing they're doing the best thing.
Maybe they're believing that they're carrying out the decedent's wishes.
Mom
But
told me she wanted this.
Right.
Well,
Right.
Mom told me she wanted that.
And the fact of the matter is sometimes Mom forgot,
Right.
and she may have promised one thing back several years ago, which beneficiary number 1 remembers, and then she might have promised something completely different 2 or 3 years later, and beneficiary number 2 remembers that. So that's why, in our opinion, being involved with this area of law, it's best to have things written down, and that's what we call estate planning. And speaking of estate planning, one of the things as part of our practice, what we like to do is we have workshops 3 times a month, once a month down the Cape, twice a month up in the Quincy area, and it's primarily for education purposes, is to let people know the different things that are out there. Not that everybody should be doing the same thing. No, people can get by with maybe a simple will plan, depending on the facts and circumstances and what they want to accomplish. Other people may need a trust or an asset protection trusts, but the important thing is to get educated as to what's out there, and that's why I think it's important, and it behooves everybody to find out about estate planning. And again, one of the best ways you can do that is to attend an educational workshop where there's no commitment, there's no cost of doing it. Again, part of our practice is to educate people. And again, I think what John and I see a lot of times is people will come in and they'll say, oh geez, I want a simple will. So in the past we've had them come in, we talk about things, and then at the end of the meeting the same person will say, and that'll protect my home, my house from the nursing home. And we'll be like, well no, that's a separate hour discussion. That's not appropriate during that client engagement. So again, I think it's important, it behooves everybody to get educated, find out what's out there, and then once you do, then you can have a separate meeting with your attorney or with your financial advisor, and to formulate your own plan based on the facts and circumstances of your own individual situation. Again, I think that's very, very important, and what we do to facilitate that is we have these workshops 3 times a month. So,
And at the conclusion of this show and every show, we'll have our contact information just at the bottom of the screen, indicating what our Sandwich office is, the address, the phone number, the email address, as well as the Quincy location too, with its relevant contact information. So please feel free to jot down the information, or just get right on the phone to call one of us, and we'll talk to you a little bit more about the workshops. I think you and I have one coming up in February 8th, I believe. I'll
Yes.
have to double check, but I think it's February 8th. And if I'm not mistaken, it's at 1 o'clock at the Council on Aging here in Sandwich. But don't hold me to that. I'm going to have to double check. I see you have an awful lot of notes there, Paul. Is there anything else you want to share with the viewers?
Well, I recently got a question from a client who called in, and the question was, if I already have a will or a trust, am I all set? And my answer to that is possibly.
Right, as usual.
But your
right?
best bet is to come in and see us and have it reviewed, because that might have been relevant. It might have been the best will or trust that could have been created
At the time.
at the time.
Yeah.
But now the facts come into play, which would be, okay, how are your assets titled? Okay, you could have the best will in the world, the best trust in the world, but if, well, like we were talking about earlier, if you have joint accounts set up, or accounts that pass via a beneficiary designation, then those are going to go in that direction to those beneficiaries, and it doesn't matter what the will says. Doesn't matter what the trust says. So I think it's important, if that's part of your estate plan, having say a revocable living trust, or even an asset protection trust, that we take a hard look at, okay, how are those vehicles funded? How are the assets that you own titled? That's very, very important. So whenever somebody calls in and we're coming in for a review of their existing estate plan, what I typically do is I send them out another personal information questionnaire. I want them to fill it out because I might not have met with them for 10 years. And I want to find out.
Or at all.
Or at all, but typically I'm just talking about a review situation. I want to find out that, okay, the assets that you do have, how are they held? How are they titled? Because that's going to have relevance to my recommendations concerning their existing estate plan and what they need to do, with their assets, or do we need to revamp their estate plan? So very, very important. And again, I do suggest that even if you think your estate plan is all set, that every 2 to 5 years, I think it's healthy. Set up a meeting, set up an hour meeting, come in and review it. Even if there's no changes that have to be done, go through it. Again, we don't expect you to remember all the legal, technical aspects of your estate plan if you set it up, several years ago. If we set it up a month ago, hopefully you do. But my experience is once people are comfortable and they have their documents in place and everything's been executed, they're nice and relaxed and they feel like everything's set up and it's the way they want it to be. And it probably is. But as time goes forward, we find out that, all right, the client has acquired, another bank account, or this bank closed down and they opened up another one, or a brokerage account, they got transferred from Merrill Lynch to some other brokerage account.
Yep.
But we want to be sure that do you have that set up and funded the way that coordinates with your estate plan. So that's very, very important because, again, I think we've both found out over time that they might be very, very happy with their will or with their will and their trust that they did 5 or 10 years ago, but then you've come to find out that the assets aren't titled correctly.
And I think what you're saying is really going to become crystal clear in terms of review and changing given the Uniform Probate Code and the laws changing this January. You and I are constantly looking at the changing, shifting laws. There's going to be a major revamping of the probate laws soon enough. So not only do our viewers have to review the plans that they have, but we too have to constantly review and counsel our clients accordingly. Which brings up another point. We talked about the workshops, but we should encourage the viewers. Always feel free to email a question to us, call in, send us your question any way that's easier for you, even by mail through the post office, and we'll do our very best to answer the question as soon as we receive it, if it's an email, or at the very least at our next show. I think that's going to be quite helpful to the viewers going forward too. That we impart so much information, and I'm sure people are taking down so many notes. And I wish they had continued on this particular subject, et cetera, et cetera. So feel free to email or call in to our office or mail us your questions, and we'll respond accordingly.
Thank you.
All right, I think that about wraps it up. Thanks for tuning in to Your Long Range Plan. We'll see you next time. Thank you so much.